Hi, is it really difficult to learn UK laws? Let's clear this up right away. No, it's not difficult for Indian lawyers to learn UK laws. The English legal system is highly accessible for Indian practitioners due to our shared foundation in common law, which originated in England. In fact, much of our legal framework, from torts to contract law, directly traces back to British statutes and cases. Indian law is closely linked to English law, making this transition much smoother. Many foundational Indian statutes, like the Indian Contract Act of 1872, the IPC of 1860, and the Transfer of Property Act of 1882, were enacted by the British. The concepts and structures within the UK's Companies Act closely mirror our own Companies Act of 2013, with shared ideas of corporate structure, shareholder rights, and governance practices. The essence of these statutes is familiar to Indian lawyers, and understanding them in a UK context is within reach. Our courts continue to cite landmark English judgments in pivotal cases. For example, decisions from the House of Lords remain influential in our legal landscape. Names like Lord Denning are well known to many of us, especially from reading cases on contract law in college. This shared history makes the UK legal system feel more familiar than foreign. Contracts in the UK are strikingly similar to those in India. Check out this English employment contract attached in the description box and compare it with an Indian employment contract attached in the description box for your reference. Do check them out. They share terms on employment obligations, confidentiality, data protection, non compete clauses, and severance terms, with only minor variations that account for local laws. Let's break down a contract law concept relevant to both systems: liquidated damages. Imagine you buy a pre owned car for 5 lakh rupees and insert a clause for liquidated damages at 1 lakh rupees in case of defects. In India, Section 74 of the Contract Act dictates that the courts will award up to this amount provided it's a genuine estimate of the loss. In the UK, the concept has evolved. While India still applies a strict interpretation, the UK's 2015 ruling in Cavendish Square Holdings v. Talal El Bakhtisi allows for more flexibility. Now, UK courts may uphold higher liquidated damages if they align with the legitimate interest of the party beyond just monetary loss. This allows factors like reputation to play a role as long as the clause is not excessive. Ready to test your understanding? Here is a sample question from the SQE. The latest position in English law on liquidated damages is that option A, all liquidated damages are in the nature of penalty clauses and hence invalid. Liquidated damages clauses must state a genuine pre estimate of loss to be valid. Option C, liquidated damages prescribe the maximum damages payable in the event of a breach. And option D, liquidated damages clauses are valid as long as they do not impose a disproportionate detriment on the contract breaker compared to the legitimate interest of the innocent party. The answer is D. This illustrates the nuanced yet approachable nature of UK law. Notice the overlap with Indian principles but with unique adaptations. Are you feeling more confident about learning UK laws? It's easier than you might think. And the SQE is your ticket to becoming a dual qualified solicitor in England and Wales. Join our free live 3-day bootcamp this weekend. Let us guide you on the SQE journey with practical examples, insights, and step by step strategies for building your career in the UK. Don't miss it, mark your calendar, and see you there.